Welcome back to the Law News Network, everybody. Aaron Keller here along with you for the afternoon, and we're in the midst of about an hour-long lunch break in the case we're covering out of Las Vegas, Nevada. It's the Valerio case, and he's facing another death penalty trial some 29 years after the original one. David Pietro is a criminal defense attorney, former prosecutor in Fort Lauderdale, Florida, and he's joining us now on the Law News Network. David, it's good to see you.
Yeah, good afternoon. Thanks for having me.
So we're talking about this case, and first of all, it's just sort of a bizarre case because you've got a guy facing another death penalty trial. In essence, it's a mini trial within itself, 29 years after the original case, 31 years after the original crime. So, it's just a bizarre circumstance to start off.
Yeah, definitely, and it's at first blush when you look at the case, you wonder why the government would even go forward and not just push for a life in prison, especially since the Supreme Court in a lot of states, like here in Florida, are now requiring unanimous verdicts or unanimous recommendations for death in order to proceed. So you usually have to get 12 people now, which is very hard to do under most circumstances, even with heinous crimes. So, but then looking at the Nevada statute that we were discussing earlier, he has a possibility of getting parole. And I think as we learned from the OJ case, Nevada, you're eligible for parole after 1/3 of your sentence. So if he gets 50 years and he's already got 25 in, he might be eligible for parole. So there's a lot on the table. It's almost basically a retrial. In a different way. It could cause, the ramifications could cause him to potentially walk out the front door of a prison. So a lot at stake.
Yeah, I mean, when I started getting into the weeds in the statute here, it started to answer a lot of the questions about what they were doing procedurally in this case, because we just had the prison warden on the stand, and he's talking about all these different parole standards and why they do it and what the procedure is. And Jesse Weber and I were sitting around the table here at first wondering where they were going with it, and then I finally went after page after page after page of the statute and found what the jury can consider, and there are 4 different possibilities on the table for the jury here. One is a definite prison term of 50 years. One is life with the possibility of parole. One is life without the possibility of parole, and then the final one, of course, is the death penalty, which is why we're back here. And I agree with your analysis here. I mean, just talk about a major change in circumstances. This guy could go from death row to walking out the front door of the prison, as you said. What a shocking change of circumstances.
Yeah, it's definitely a strange scenario that I haven't seen before. Florida, like a lot of states, we got rid of parole. Everybody has to serve 85% of their sentence, and murder is a life. I mean, we also have life, and life means life. That means you leave in a pine box. So it seems this is kind of a strange scenario. Maybe that's an old statute they're operating under that was from years ago, and it's since been changed, which could happen, or it's the current statute. But
yeah, this is the current statute.
A lot at stake.
I'm assuming that the current statute is what they're doing procedurally here. I haven't seen anything to suggest that they're dialing it all the way back to the original statute. So we're talking about a crime from the mid-'80s. They'd be dialing it all the way back to the 1977 version of the statute, because it wasn't updated until 1993, and that was after the original case. I would seem to think that procedurally they'd be using the new statute. Would you agree or disagree?
I would. It depends, but I would think that it would be the old statute, because that's when the crime had occurred, unless it's a procedural issue. Procedurally, they can update it, but if it's the law, what the law was at the time, you can't change the law after the fact. So it might be the old statute they're operating under, and causing kind of this weird scenario that we have, because most model penal codes have been updated. And this parole and things like that have really been changed and reshaped. So it'd be interesting to know.
Yeah, I mean, and that's why I said procedurally. A lot of what we're talking about here is just the procedure of what the jury can and can't consider, when it comes to the sentence. I really am curious now, and I'd have to go look at the specific court records there to try to unwind that issue, but it's been a question on my mind. So, let's talk about some of the other things here. Let's talk about this aggravating and mitigating factors, because my read of the statute in Nevada is that there are circumstances that could involve the, quote, aggravated nature of the offense itself. And if the offense apparently is severe enough, my read of this is that he could get the death penalty just off of the severity of the crime itself. That's the way that the death penalty hearing statute reads. But then there's this other list of aggravating factors, which from my read is not really helpful here, because most of them don't, they don't pertain to this particular factual circumstance. A lot of the the aggravating factors in Nevada are things like, whether the crime happened on a school or whatnot, and did it involve a peace officer? Well, no and no. So how does the jury pick through this sense of whether or not this was an aggravated crime if they really want to move towards the death penalty area here?
So the jury will have to decide normally in these death trials, because usually when there's a death penalty case, you have two lawyers. You have one that tries the case, and if you're convicted, then one that defends you on the aggravating and mitigating circumstances, so that a lawyer doesn't look like they're talking out of both sides of their mouth. So I guess the state's going to have to prove that the aggravating factors are in place, and one, it would be the heinous nature of the crime, and presumably other aggravating factors about his life and prior crimes would be admissible to show that this is not his first time of being involved in the court system. And then mitigating factors could be presented by the defense as it relates to he was abused as a child, he has mental deficiencies, things like that can be, or alcoholism, drug addiction can be used as a mitigating factor.
Yeah, I mean, the list of mitigating factors is relatively defendant-friendly here. It's a list of things like no significant history of prior criminal activity, whether or not he was suffering from extreme mental or emotional disturbance, whether or not the victim was a participant in some way in the circumstances that led to the death, whether the defendant was of youth, and then it's got this sort of catch-all factor, any other mitigating circumstance. So in theory, that gives the defense a pretty wide berth to throw anything at the wall and see if it sticks as a mitigating factor.
That's probably why they had the lady from Massachusetts and the religious friend. So that, I guess the defense can basically throw on anything they want because of that catch-all phrase that they believe might be mitigating.
That's how I saw it as well. And when we saw that witness on the stand, she's a minister who is up in the Berkshires working with smaller congregations now, and apparently she writes to death row inmates and ultimately wound up forging a friendship with the defendant here. She's even gone to visit him. She talks to him on the phone, and I thought that the testimony was interesting at a minimum. How do you think the jury might take something like that?
It's hard to say. I mean, that's bizarre, right? I mean, unless they believe that she's some devout person, and that she does these kind of outreaches to other people in the prison system, and it's just against the death penalty. If it's just him alone, then it sounds like one of those weird relationships where women or men, in that case, will have formed this relationship with somebody in custody.
Yeah, I mean, she said that she maintained the friendship through, quote, an easy flow of conversation back and forth with the defendant. Describes it as a two-way friendship, says that she considers him a friend, she cares about him, he asks about her life, and the cross-examination got into whether or not she belongs to a congregation or a denomination that's specifically against the death penalty, and she said, well, we kind of are, but the denomination's decisions, rulings, whatever you want to call them, their beliefs are not binding on people sitting in the pews, which I thought was kind of an interesting reaction, because from what I know of the UCC denomination, it tends to be one of the more liberal denominations out there. So it's not really surprising that we're getting this kind of testimony about somebody who's a member of that particular denomination. I thought that the cross-examination was good because it at least got into some of her biases. And that was the subject of a big evidentiary hearing last night on exactly what the prosecution was going to be able to do with her. Do you think that was on the ball, or do you think that the prosecution should have done a little bit more?
No, I think that's probably on the ball because she's a bias in her beliefs. So under any circumstance, she's going to say that somebody does, that she doesn't believe in the death penalty. So she's on the polar extreme of where the state's pushing what the law is. So I think it's good to challenge her beliefs and where they come from. But forming a relationship with somebody behind bars, on a death penalty situation, it's bizarre. So I think the jury's going to wonder what's this all about, because it's not an everyday act that somebody would do.
Yeah, I want to take a break here, David, and continue listening to some of the testimony from the medical examiner who was on the stand in surrogate form, at least yesterday evening. The medical examiner apparently was not available to testify in this particular hearing, so they had somebody reading her testimony from the original case 29 years ago. Let's go to clip 18 here. I want to listen to some of this, and we'll be back in a second.
Would you tell the jury the force required to inflict these kinds of wounds?
You need a fair amount of force because it's the blunt trauma that breaks the skin, and that does require force. For instance, if you stand up under a cabinet and hit your head, you don't usually tear the skin. You might get a black and blue mark, but you don't tear the skin, so that when the skin is torn, there's greater force.
And you are not able to tell us the instrument that caused those wounds, are you?
No, there's no pattern there.
Can you tell us whether those particular blunt force trauma wounds occurred before or after, or at the same time as the knife wounds found throughout the body?
At the stage of decomposition that she was in, I could not say. It would seem likely that they occurred before the knife wounds.
Why do you say that?
I can't imagine someone sitting still for 8 knife wounds to the top of the head.
Let me ask you in relation to that. Let's assume hypothetically that the blunt force trauma wounds to the head being hit over the head was the first thing of all the wounds that you saw in this body that occurred. What sort of an effect would that have on the person receiving it?
I think it might incapacitate them temporarily.
What do you mean when you say incapacitate them temporarily?
Make a person dizzy, perhaps, and not necessarily lose consciousness, but just make them unable to move temporarily.
And for how long a period of time would you place on the word temporarily?
I think it may be between seconds and minutes.
It could be as long as a minute.
Yes.
This would be short of rendering a person unconscious, but not allowing them the ability to move as they normally would.
Yes, I think so.
Thank you. I have no further questions.
Okay, David Pietro, criminal defense attorney from Fort Lauderdale. It's a clip of how the medical examiner's testimony was read into the record here, and I thought maybe you could give me a little perspective about the rules for how to deal with it when a witness is unavailable. And I suspected this would happen in this case because the original trial was 29 years ago and the crime was 31 years ago. So a lot of the people originally involved are either dead or they're very, very aged at this point, and presumably not all of them can testify. So again, pretty lockstep procedure, but interesting to watch it in practice.
It's I hate when I have to read in testimony to a jury. It's the worst way to present evidence because the jury, not only did they, it's not just the evidence, it's there's a feel for people, whether they were candid, where did they make eye contact, did they seem genuine? Did they seem experienced in their area if they're an expert? And those kinds of things. And it's just a terrible way to have to present evidence. But if you're the prosecution and your witness is not available, you have no choice. So they're stuck with it. But that's a tough way. So if there's salient points that the medical examiner brought out, it's important that the prosecution in closing argument point those out, because people can fall asleep during this. It could be very boring. So you get it in the record, and then you have to present it in your closing argument to really flush it out and point out the importance of it.
Yeah, you make a good point there. They're not able to really listen to the original medical examiner and pick up on her demeanor, figure out exactly the way she's behaving on cross-examination. That said, medical examiners usually are rather sophisticated witnesses because they're used to sitting in that chair. I would think that having live testimony from a medical examiner, the actual medical examiner who examined this particular victim, would be less important than perhaps an eyewitness whose credibility, veracity, viewpoint, and everything really need to be dissected by a jury.
I think you're right. The medical examiner can talk about the heinous nature of the crime, how it was committed, where the wounds were, and the time and length of the struggle and the ultimate cause of death. So there's value in it, but you're right. I mean, there's going to still be photos and other testimony that's going to tie it in anyway. So it's an important factor, but not the crucial factor to get the job done.
Certainly. So I was surprised that the state really only called, I think, 3 witnesses here before they rested, if I'm remembering this properly. They had the medical examiner and they had a couple of investigators. I didn't see much beyond that. And then the state rested first thing today. So is that a surprise to you at all? Because I've not really been given a chance to witness one of these death penalty phase cases before. Are they normally that short?
No, they're normally pretty long. I mean, I know here in Broward County, when we have redos of death penalty portions of trials, they go on for months and months. I mean, it's just basically a redo. You start bringing in all the people that that can support the aggregating factors, and if there's past crimes, you have to bring up all the past crimes, and it could be a protracted period of time. I'm surprised it was so limited in witnesses, especially with all that's at stake. If it was a matter of life or death, then I guess, for purposes of protecting the public in the future, it's a foregone conclusion. But this has a possibility of him walking out the front door, which raises a much different level of protection for society.
Yes. Now, another little interesting nugget that I found in the Nevada statutes for the procedures for these death penalty phases is this one. Hearsay rules are out the window in these things. So they could bring hearsay in. And there was a big argument about this outside the presence of the jury yesterday, because the defense tried to really box one of the witnesses into the corner and say, well, you're testifying about something that you weren't there to see. And the judge did allow the defense to go there, but apparently the rules for these particular proceedings in the state of Nevada are such that hearsay doesn't count. I also thought that was kind of an interesting little procedural twist here.
Well, I think that would be in line with Crawford v. Washington. So the right to, the Fifth Amendment right to confront your witnesses. So and them having actual knowledge, it would make sense to me that the witness would have to be present and be able to be cross-examined, and that hearsay would not be admissible, generally speaking. So I think it's a confrontation clause issue that would have to be fared out. And if the prosecution was allowed to bring in hearsay, I could see that being an appealable issue in the future.
Well, that could drag this thing out for another 30 years if that were the case. But it's another interesting little procedural quirk, and I think that they were trying to use it to say, okay, well, this particular witness was involved in the original crime 31 years ago. This particular witness was investigating the crime 31 years ago. And he's relying on reports from other police officers because they didn't get into the details, but I'm assuming that those officers are either no longer alive or just not in any kind of physical state to testify. Do you think that this rule is just not a good rule, or does it benefit the state in just trying to get the police records on without having to worry about all the procedural steps of declaring a witness unavailable and then having somebody else read that witness's testimony into the record and all these other procedural hoops?
Yeah, I think reading the prior testimony of the record is okay. Procedurally, I think reading reports and relying on reports is a issue that I can see being brought up on appeal and going the other direction for the prosecution. because of all the case law that's developed since this murder occurred. And in particular, that Crawford v. Washington case, which was a Justice Scalia opinion about being able to confront your witnesses and having them present so you can cross-examine them. So I can see this being a particularly interesting legal issue down the road. And this is the problem with the death penalty cases is they're very much scrutinized by Supreme Courts in the various states. So, and there's an argument that sometimes they're overutilized and these things can happen. Whereas if somebody's just convicted for life in prison, they get much less scrutiny. Like here in Florida, if you're convicted of life, your appeal goes to the appellate court, and then you likely don't have an appeal to the Florida Supreme Court. And whereas in Florida, if you're convicted of death, you go immediately to the Supreme Court, and it's just really overanalyzed, and it's really scrutinized, every little thing that happened in trial. So sometimes this is what can happen. You get these old cases, and cases aren't like wine. They don't get better with years, so they only get better for the defense. And these kinds of things can happen.
I'll have to write that quote down, David. Cases are not like wine. Good to know. But we're going to continue listening to some of the testimony of the surrogate who is reading the medical examiner's testimony from the original